Good evening. This is the September 12th, 2024 Garbage and Recycling Advisory Committee meeting. I'm going to share my screen with some basic information that we usually share. Okay, give me just a second to open it up. Okay, now I'm going to share my screen. Sorry about that. A little crazy. There we go. So again, this is the September 12th meeting.
My Lingo team, I cannot hear any information in Spanish.
Okay. Let me know if you are now, and then I'll keep going. So everyone should be connected via audio upon entering the webinar. You don't have to call in. You're automatically muted. The presentation is recorded and it will be posted to our solid waste and recycling webpage within a week. The agenda holds time for public comment. They will be permitted per committee rules and at the discretion of the chair. And if you're having any trouble, we do give a web link to help you out. The bylaws on public comments state that only the committee chair may recognize a public attendee. You can use the raise the hand feature to indicate your desire to participate. There's a designated time on the agenda that allow members of the audience an opportunity to speak to the committee. And once recognized by the chair, the response should relate only to the request made by the committee and may be subject to a time limit. And then finally, we do provide translation services. It's being supported with Spanish translation. Panelists and attendees need to actively select between the Spanish or English room, and there should be an option to toggle between the two. In terms of translation, and then just generally, we do have some best practices. If you could try and speak clearly and in a normal tone, and only one person speaking at a time, and then use the raise the hand feature and ask for clarification as needed. And now I'll stop sharing. So with that, I will turn it over to Ashwin as chair.
Yeah, thanks, Kathy. Good evening, everybody. Thank you for joining us again. It's been a while, so I hope everyone had a good summer. Yeah, I don't have much else to say. So Kathy, if you're okay doing roll call, and then we can go into CRAC communications and updates.
Sure, I'll do roll call. Ashwin Nataraja.
Present.
Sandra Smith.
Present.
Leslie Albert. Christy is absent. Aaron is absent. Myra Hernandez.
Y presente.
Pete is absent. Bernard is absent. And Brian St. John.
Present.
Okay, with that, roll call is complete. Don't have a lot to say. Aaron did send out an email that spoke a little bit about our ongoing efforts to recruit a solid waste and recycling division manager. We did do recruitment, but unfortunately, we were unable to have a candidate take the position. So I am guessing that shortly it will get reposted and we will recruit again. So right now in the interim, Aaron is continuing to take that role on of being the interim solid waste and recycling manager. So to the extent that anything comes up, it's still funnel through her. We are in hopes that we'll be able to fill the position sooner rather than later, but we just don't know. There haven't been a lot of program updates. The Recycling Modernization Act that you've heard a lot about is continuing. We did file comments on the proposed DEQ rules back at the end of June. We have not seen either a revised draft of the rules or the rules, the way DEQ works. Once they get their package of rules that they want to submit, it has to go to another sort of body, which is the EQC, and then they're the ones that ultimately adopt them or not. There hasn't been anything at least circulated publicly on that, so it's still, I think, I heard there were over, I don't know, pretty much there were a lot of pages of comments. So I'm sure it is a heavy lift to like go through all that and kind of align it with what the legislation said and make sure that, you know, there may be things that get raised that they want to tweak in their proposed rules. So we're hopeful to see something about that this fall. We continue to be working our way to the July 1, 2025 date, which is when the first sort of actions take place from the producer responsibility organization. So it's not that far away. And, you know, I anticipate that from a solid waste and recycling division, we will be doing an administrative rules update as soon as we get more direction in terms of what the DEQ rules look like. At the very least, we need to align definitions, naming conventions, what's included, what isn't included. For example, there is a discussion going on about whether glass collection will be continued curbside or does it move to a depot model, which is how it's handled in much of the state. But, you know, in the Portland metro region, we have sort of the ability to have it as part of our monthly package of collection services. So there'll be more to come on glass. Some of it probably depends on whether wine bottles get pulled out to be redeemables or whether they stay outside that program and in our regular services. But that's just one change that could ripple back to us. Plus, we haven't done an admin rules update in like a year and a half to 2 years, and there are both changes that have come up that we've noticed over that time period, plus some new things that we want to add. So you can expect probably hearing kind of like the last time, a few meetings of here's where we're at, what do you think? And get your input and then revise, and with ultimately it getting voted on and then going to the board for final approval. So that's about all I have for program updates. In terms of the calendar, we're still thinking about bringing an RMA, at least heads up, kind of short presentation in October. I don't have anything for November at the moment. And then December is our third year of certificate reviews. We've done 2 rounds so far. I'm reviewing SWATCO and Walker garbage this year. So that'll be, plus I'll give you an update as to whether Waste Management and Evergreen, who were last year, if they've completed the actions that they needed to take in order to meet the code and the admin rules. So the December meeting, the code says we have to do it by the end of the year. So that one is for sure. And then just food for thought. Our bylaws say that we have to meet, that GRAC has to meet at least once a year. And generally meetings are held monthly. So there's a lot of leeway. And we've been wondering whether it makes sense to have a standing monthly meeting or whether we want to move that to something longer. So no decisions tonight. We don't even have to, I just throw it out there, just let you know that we've been sort of considering, the pros and cons of both, either having monthly meetings or having a standing quarterly meeting with other meetings as needed. Because if you have to take an action, something comes up, obviously we call a meeting, or every other month, or staying with monthly. But it's a challenge to find, I want to make it beneficial on both directions. I mean, getting your guys' input is very important to me, but also providing information that you find valuable. And sometimes it's, this year in particular, we've had a bunch of cancellations. So I just would like y'all to think about, what you think makes sense, and maybe we'll put it on the October sort of general communications topic and explore it a little further.
Yeah, thanks, Kathy. I remember when I first joined 5 years ago, we met like 3 times a year, probably. And maybe just because the activation energy of meeting in person was a little bit higher than the virtual meetings. And then it got pretty frequent there for a while, and it seems like we have less topics again. Do you have a concern if we keep it monthly but then cancel without topics? Do you think there's like a benefit to just not have like going with quarterly and then adding as subjects goes versus?
I think there's pros and cons with both of it. One of the things that I was thinking was if we move to quarterly, maybe we can publish the agenda like 2 weeks before, or some longer period to allow for more time for folks to first of all see what's going to be on a meeting and plan for it, and then but on the same hand, same token, it doesn't hurt to have a standing meeting. We just cancel it. Yeah, it's just more of like logistically, how do we want to go forward? And coupled with that are questions about, do we stay hybrid? Virtual? Do we go to hybrid? Do we go to in person? Do we go, some combination? I think there's going to be a lot of discussion around that this year. So or going into next year. So I just throw it out there as possible, as a topic that you as the advisory committee could be thinking about and provide input.
Yeah, food for thought.
Kathy, do you have a specific way you would want us to provide that input?
How appropriate given our topic today of discussion, but this is a logistical thing. This is about meeting, frequency, things like that. You can send me an email, or if you want to outside our meetings, or we can make it, we have a couple of items at the top of our agenda that are GRAC communications and other issues. We could make it part of that if you want to do it within the forum of the group itself. Either way, or both.
Yeah, I think we should just like look at the agenda of the upcoming quarter and then say, hey, do we want to group some of these things? Depending on the length of the topic. Some of those meetings that are 2 hours long can get pretty difficult in the evening for folks to stay on. And
if we schedule it for a meeting topic, I think we got to do notice to everybody, because that might be the one meeting I can't go to, and then at least gives me an opportunity to have that written feedback or something prior to the meeting that you guys can use for discussion.
Makes sense. Cool. Thank you, Kathy. Next item up is committee news and calendar updates. I don't know if folks on the committee have anything they want to share about any upcoming events or news I think is interesting.
I'm trying to figure out how to raise my hand.
Just go ahead. Yeah, go ahead, Sandra.
I got an email saying that PlanetCon is not only not having something this fall, but they're not having anything next year. And I was wondering if the county or anyone's planning to do anything in the meantime or something like that. Kind of disappointed about the whole thing, but I know it takes a lot of people and maybe it's just too much. I don't know.
Did they give a reason why?
I'd have to go look at the email. I think they were just gonna look at revamping the whole thing or something.
Hmm.
I can take this back to our education outreach group and you know, get some information that I could share. I don't know. I didn't know, and I don't know both. I didn't realize that PlanetCon had been canceled for that length of time, and I haven't heard anything about any plans to replace it or do something similar. But
Because
there
we'll
might
the time during this break to figure out the future of PlanetCon and the WPA, which is West Side Planet Alliance. They're not going to host the PlanetCon event in 2025.
Any other news, questions, or folks have subjects they'd like to see on the calendar this fall?
I've got one subject I'd like to see maybe coming up at some point, not anything particular, but as I've been doing some reflecting, I don't know if we've done enough analysis looking more upstream at the root causes of issues that we talk about here. And we do seem to talk a lot about downstream and how we can help the county residents. Just thinking maybe if we can work something up in there at some point to because I would love to be able to be part of something where we could put our name on a document or a petition asking for change at industry level type of thing. Does that make sense?
Mhm. So by upstream, do you mean from like the kind of like from RMA, in the sense of RMA, like
yeah, like at the moment of production.
yeah. Yeah, that might be a good discussion to have as part of the RMA update. Like what are they doing versus what do we want to see expanded to? So that will be a robust discussion. We can get that in October. Make all Halloween costumes recyclable, for instance. Cool. Well, thanks everybody. Next item is oral communication. So we have Beth and the public attendees. If you want to raise your hand and make a comment, we can promote you. If not, which looks like not, we can move on to our main item, the presentation on public meetings and ethics. I'm going to go ahead and take over.
Sure. So hello, everyone. My name is Eamon McMahon. I'm an attorney with the County Counsel's Office. Thank you all for being here and for being part of the GRAC. We know the good work you do is important to the county. So what I'm going to do here tonight, I'm going to switch over to a PowerPoint in just a few moments, is kind of walk you through sort of the basics of a few different things that sort of relate to your role as members of the GRAC. Because you are public servants, and that means that rules relating to public meetings, ethics, and public records all apply to you and your work within the GRAC. So what I'm going to do tonight is walk through kind of an overview of what those rules are and how they affect and impact your work. And then sort of at the end of it, what I will do is I will provide some resources for you to contact if you have further questions about ethics, about meetings, about public records, and all those sorts of things. So I'm going to switch over to the PowerPoint here in just a moment. I think we're going to go. Sorry. A little rusty on my Zoom presentation, so you have to bear with me for just a second. There we go. And then we're going to go ahead and go to from the beginning. All right. So this is sort of what you need to know. We're going to walk through 3 separate topics. The first topic that we're going to talk about are public meetings, like the one we're having right now. The second topic we're going to talk about are public records, sort of what that entails and what your obligations and requirements under Oregon law are with respect to those public records. And finally, we'll discuss ethics laws, because as public servants, you are constrained by the Oregon Code of Ethics. And again, this is the sort of thing where we just want to make you aware of what these laws are. And of course, as a lawyer, I'm going to do a couple of lawyerly things that non-lawyers hate and that all lawyers hate having to do. But here tonight, this is not legal advice. This is me sort of just walking you through the laws. I am not your attorney, and it does not create an attorney-client relationship. This is sort of for informational purposes only. If you have other questions, you'll need to contact a lawyer, or you can reach out to some of the resources I'm going to provide a little bit later today, which specifically are from OGEC, or the Oregon Office of Government Ethics. I think it's the Oregon Governmental Ethics Commission. There you go. That's what the acronym is for. So I will provide some links to that website. They have resources for you to contact if you have questions. They have handbooks about the public meetings and about public ethics that can hopefully address any more specific questions that you might have. So again, tonight is just sort of an overview of these statutes and requirements that will sort of help guide you in your role as members of the GRAC. So let's start with public meetings. This is the Oregon statute that pertains to public meetings. The notion behind this is that governing bodies make decisions and that those decisions are arrived at openly. The idea is that, we don't want shadowy cabals running the government. And so what we want to do is we want to have any governmental body that meets and deliberates and makes decisions are open to the public and are viewable by the public, and that the public can engage with the decision process of those meetings. So that's sort of the overarching objective of the public meetings law. Now, let's talk about what that has to do on a more specific level. This is the list of sort of what applies for public meetings. They're the governing body of any state agency, regional government, county, like Washington County, city, special district, or municipal corporation, something like Metro. And those include boards, commissions, subcommittees, and advisory groups. Now, you, as members of the Washington County GRAC, are members of an advisory group. So these meetings do fall under the umbrella of the Oregon Public Meetings laws. Your meetings are subject to public meetings laws, and you must abide and follow the public meetings laws. So we'll talk about some definitions. The first definition and the first rule is that all meetings of the governing body of a public body shall be open to the public, and all persons shall be permitted to attend any meeting except as otherwise provided. Now, there are a couple of exceptions, and if you'd like to, you can go look up the statutes. It's pretty dry, but we'll talk about sort of the general rules and what that means. So we've talked about public meetings. We talked about why it must be public. What is, under the law, quote unquote, a meeting? Well, a meeting is, as the statute describes, the convening of a governing body of a public body for which a quorum is required in order to make a decision or to deliberate towards a decision on any matter. It does accept a few things, including on-site inspection of a project or program, and does not include national, regional, or state associations to which members may belong. That includes things like if you're going to go to a conference or a convening to discuss these issues. Yes, Ashvin, I see I have a question.
Yeah, just you're in non-presentation mode.
Oh,
So the text is getting cut off at the bottom. Want to like swap screens? Might help.
okay. I'm trying to. Let's see here. No, that's not what I wanted to do. No. Sorry, thanks for bearing with me. This is not, let's see here. Did that do it?
Yep.
Great. All right. Thank you. Sorry about that. Okay, so a meeting involves convening, which I know we're getting into definitions and everyone kind of hates those, but these are important for under the statute. So convening means gathering in a physical location or using electronic, video, or telephonic testimony to be able to communicate contemporaneously with participants which includes this kind of a meeting, using serial electronic written communication among participants. A good example of that is an email thread. If you're replying to an email thread with multiple individuals, that, for the purposes of the statute, constitutes a meeting. Or using an intermediary to communicate against participants. That's if you have a messenger and you want to send something around, and essentially that's there to avoid circumventing the public meeting statute, because people can read the law and try to find all kind of loopholes. And what that means is that prevents someone from who's like, aha, I know how we can avoid the public meeting statute. I'll get a page and I'll tell them what I want the other members to know, and we'll just send them around. We'll play a big game of telephone. We'll come to the agreement we need to, and we don't have to have a meeting that has to be open to the public. That's why that little kind of last nubbin is on. So what I would encourage you to think of is, when we're thinking about meetings, is to construe it broadly. If there's any question about whether or not something constitutes a meeting, my advice to my clients, I always say err on the side of considering it a meeting, because it's important to comply with the statutes. Again, the objective is fair and open communication regarding matters of public interest. And so whenever we're dealing in this sort of realm, whenever we're talking about government work and government advisory, we always want to err on the side of disclosure and openness. So if you have any questions about that, if you ever feel like you're wondering, like, gosh, I wonder if this is a meeting or if this is something that should be open, I would encourage you, again, contact OGEC. But you can't go wrong if you lean in favor of indicating that it's a meeting. Yes, Brian.
Appreciate it and totally understand you're not our lawyer, so respect. I'm curious, because I've been debating this since, I'm a newer member to the committee. Say, I'm chatting up Sandra, and I find out she's a golfer as well. And we decide we're going to set up a tee time, and we text back and forth, or we email back and forth. Is that considered communication that, someone like a Freedom of Information Act type of thing could get access to, because we're two GRAC members? I don't understand where the line divides, or is that coming up later in the presentation?
So I think there are sort of two questions in that question. And sort of your second question, are we going to go through hypotheticals? And the answer is absolutely. I've got 4 hypotheticals up. We'll talk about just exactly that. With respect to the public records, and so everyone kind of talks about Freedom of Information, or FOIA. That is a federal statute. The one we're concerned about is the Oregon Public Records Act. That's sort of what applies here, because we are a state agency. It gets a little trickier. And again, this is something where if you have any specific questions, I would strongly encourage contacting OGEC. And this sort of falls a little bit more under the public records conversation, and we'll talk about that a little bit more at length. But if you're using your personal phone to contact someone who happens to be on the committee with you, and it's not about business and it's not about the contents of what's going on, then that's probably not going to be considered a public record. It's not something that pertains to this, so it isn't going to be considered a meeting. Now, there are some things where if you're trying to say, hey, let's just meet up for golf, and oh, by the way, when we're playing golf, let's just have I'm here, you're here, this is great, let's just have a chat. And someone shows up, then there are potentially some situations where that might actually become a public meeting. So I would encourage you to always sort of be cognizant and mindful of the statutes, and again, right, to reach out and contact folks if you have any questions, and to err on the side of, we're playing golf, we're having a conversation, and the
right,
issues of the GRAC come up, and it's like, you know what? Let's hold this conversation for when we're actually meeting in GRAC or doing something a little bit more official, so there isn't any question about whether or not we're complying with the public meetings law.
Yeah, because I haven't had a chance really to meet anybody yet in person. I think I met Kathy when during maybe the interview process. But I do hope to, get to know my fellow GRAC members better. And I would like to do that maybe in a setting outside of committee, but I have just been super nervous, right? It's one of those things where I'm like, I don't want to get in trouble. Does that make sense? Okay.
It does. And I think your instincts are in the right place. And I will tell you that you probably don't need to be that nervous, but that again, your instincts and erring on the side of caution that's a great place to start. And it's easier to sort of go from that place to figuring out what is acceptable. And again, we'll talk about 2 slides. We're going to talk about some acceptable examples of communication than sort of what it is. But I would again sort of point to the language of the statute. And there are two key components to it. The first is that it's a convening a governing body for which a quorum is required. So that's sort of the thing. You're meeting and requiring a certain number of members to be there to make a decision or deliberate to a decision on any matter. So if you're meeting up to golf because you just want to get to know the members, heck, even if everyone meets up because you want to get to know each other better, I guess I'll ask you a question. Is that for the purpose of making a decision or deliberating towards a decision on any matter?
Yeah, no, it wouldn't be. It would just be camaraderie.
Exactly. And for that reason, it would probably not fall under a public meeting. Now, it could very easily become a public meeting if in that golf outing, where let's say all of the members of the GRAC were there, and you decided to start talking about the GRAC. Then if all the members were there and there was enough of a quorum, I think that would probably constitute a public meeting. So the edges on this are fuzzy, and that's sort of why I go back to my overarching view, which is if you're at all concerned or worried or think that this might be sort of getting towards public meetings territory, always err on the side of treating it like a public meeting. Okay, so let's move on a little bit. We can talk about meeting minutes. So this is a requirement of something that qualifies as a meeting. And of course, today we've already sort of seen that in action. So the body must either take a sound, video, or digital recording of the public meeting, or keep written minutes of the meetings and executive session. And this sort of goes through the things that those minutes must include, including the members that are present, actions taken during the meeting, the results of all votes and who voted, unless of course it's more than 25 members, which probably isn't going to apply here. Sort of a summary or substance of the discussion on any matter that provides a true reflection of the matters discussed in view of board members. So that's potentially open to interpretation. By having a recording, it makes it pretty easy because everyone can just see what's said word for word, and it's not someone's summary that might skip certain important points or forget or be incomplete. So I think doing a recording is a great way to comply with this part of the law. And it must reference all documents received or discussed, unless there's an exemption in the public records law. And there, again, we'll talk about public records in a few minutes, but there are a few exceptions. Yeah, Kathy.
So the way it works, the way we've been doing it is we have recordings for every single meeting, regardless of whether any actions, voting occurred. When we do have an item that requires a vote, been writing mainly for the convenience for posting on our webpage so that folks that want to quickly see what the results of something are, they have it in written form. I've been doing a meeting summary. Can I do both? I mean, is that still okay?
Absolutely. Again, lawyer speak, we call that belt and suspenders, and we love belt and suspenders. It again shows that you are going out of your way to comply and that you are doing everything you can to comply with the statute. So if in question, and it's like, well, I can do this, or I could do this, or I could do both. Do both. That's something where, you know, you know, as long as you're in compliance with the law, that's kind of the objective. But there are some cases, sort of like the ones that Kathy outlined, where that belt and suspenders approach might make it easier, and might make it easier to convey to the public the good work that you're doing and sort of what happened and the results of those meetings. Okay. So now we get to talk about hypotheticals. So this is the interactive portion, which I know people love and hate, and it's terrible and it's awful on a remote call, but we'll try it the best we can. So let's start with the first example. Let's say that there is a telephone discussion between two council members. Does anyone, by raising their hand, think that this constitutes a public meeting? I'm not seeing any hands. And the answer to this one is a lawyer's favorite answer, which is it depends. So in this case, remember that the statute talks about meetings that require a quorum. Well, it doesn't define what a quorum is. So if you have a particularly small advisory board or government group, or you set the quorum for the group at a very small number, such as 2 people, then that could in fact constitute a public meeting if you are discussing something to be passed. So if the GRAC decided that a quorum constituted 2 members and 2 out of 3 or however many and two folks were talking on the phone about an issue around GRAC, that could potentially constitute a public meeting. The question is, does it meet quorum? And that's a situation in which it seems like an extreme example, but it could technically be a public meeting. Now, of course, if it's sort of like an example that Brian was giving, where we're talking about, you know, if Brian wants to call Sandra and be like, hey, I want to go play golf tomorrow, you want to come with me? That, because it doesn't concern anything that's being deliberated or decided on, that's not going to be a public meeting. But if Brian calls Sandra and says, let's talk about the meeting agenda, and a quorum is 2 people, then that would constitute a meeting. So again, it's a very lawyerly answer, and it is kind of a trick question, but that's sort of what we want you thinking about. Like, what are the requirements and what sorts of things have to apply for it to be a public meeting? Okay, let's talk about the next one. What about an email conversation in which all council members are copied? By raising hands, does anyone think that this might be a public meeting? Okay, Brian, Leslie, and I'm going down, seeing a couple people. Yes, so you are correct. That one is, it could potentially be and is probably a public meeting. Now, there are cases when, you know, again, if we're talking about organizing a holiday party, that's not something about discussion or deliberation. But if it's about an issue that's in front of the board, and it says, hey, what do you guys, what do you folks think about this? Here's this issue, let's just chat about it via email. That potentially is a public meeting. Now, it's usually not, and it can't really be a public meeting with that first message. So if someone sends something out saying, hey, we've got this agenda item tomorrow night, what do you think? And the only response to it is a response that your lawyer, I'm sure, would love to see, which is, hey, that sounds like a great topic for a public meeting and not something we should be discussing via email. Let's save it for the meeting tomorrow night. Then that's probably not a public meeting because there isn't that discussion and it's not going back and it's not deliberative. But if other commissioners or other council members start replying to it, then it kind of has become a discussion. And so it would fall under the scope of a public meeting. So again, it's another great lawyerly sort of trick question that it does depend. Hey, Kathy, yes, Kathy.
So when I send out my week before message, reminding folks that there is a meeting, look for your invite. There's one item on the agenda. I don't talk about any substance. It's just simply a heads up about the next week. And it goes to everyone and more on the advisory committee. That's not a meeting, right? Yeah.
That is not a meeting. If someone were to reply to it and say, oh gosh, like this is on the agenda, here's what I think about it, and people were to start replying, then it would convert it into a meeting. So I know that's sort of a theme, but there are things that aren't meetings that can very quickly become meetings if the wrong things are done. So it's really being careful about the discussion and deliberative process, the quorum, and sort of the purpose of that discussion. Which brings us to our next example. How about a discussion between a quorum of city council members at a holiday party, right? Brian's golf outing. Who, by a show of hands, thinks that that would be a public meeting?
It depends.
Hands. Yep. Yeah, it seems like everyone's agreeing that that would be a public, and that is right. That would be a public meeting. So as long as that discussion pertains to an official question. If that discussion is, what are your plans over the holiday and how are you going to spend your vacation days? Probably not. But as soon as it starts a question or a discussion of a topic before the board, then it is a public meeting. Finally, what about training sessions? Like, say, the one we're doing right now. Who thinks that that would be a public meeting, or more specifically, would be required to be a public meeting? And actually, it's not. That one is something where, again, it's not a deliberative process. You are just sort of learning about, you know, it could be county IT. It could be, you know, a presentation from me talking about, here's what governmental ethics are. It could be from someone saying, hey, here's how you use your county issued laptop. But because it's not deliberative in nature, even if it might have a quorum and even if it might be in an official recorded meeting like this, it doesn't necessarily qualify as a public meeting. So I know it was a lot of kind of gotchas, but I think the purpose of this exercise is to get you to think about what are the components of a public meeting and how does that apply, and to show that there are some instances where things that on the surface might not appear to be a public meeting can very quickly become a public meeting. Or things that look like a public meeting might not actually be. Yes, Brian.
So maybe this question more for Kathy. Who's our resource to bounce this question off of to either say yay or nay if one of us is uncertain? Is that, I don't know if it's Mon, is that you or somebody else?
I'll take that. Talk to OGEC, and I'll send you the links here at the end of it. OGEC, again, here, I'll pull up the website, but OGEC is a resource that all governments across the state of Oregon use, and you can contact them. And it has a bunch of FAQs. It has something where if you are concerned or worried about whether or not something, potentially runs afoul of public meetings laws, or, questions about governmental ethics, they have contact information and they have resources to help you navigate that process.
So is there like a human there though I can talk to?
I believe there is, yes. And I think you can get like advisory opinions and that sort of thing. Yes, Ashvin.
Yeah, just to make sure I understand it correctly, it seems like you both need to have a quorum and to be deliberating about that. Is that
Yes.
correct? So like I can talk about a subject with one person if that's not considered a quorum?
Yes.
Okay.
And that's informal discussions, but again, that's the sort of thing where the requirement of the statute is the quorum for deliberative process.
Okay. It's both of those at the same time.
Yes,
Yeah.
it's an and, not an or.
Yeah.
Okay. All right, so that's kind of the end of the public meetings law. So now we'll talk about public records, which kind of go hand in hand with it. So a public record is any writing that contains information related to the conduct of the public's business, including but not limited to court records, mortgages, deed records, prepared, owned, used, or retained by a public body, regardless of physical form or characteristics. And that basically means that anything you're putting together regarding county business is a public record. And there are sort of limitations and discussions about what those writings include. They can be emails, text messages, Google chats, audio recordings such as this meeting, though there is a small exception for voicemails, handwritten notes, calendar entries, to-do or tasks lists, audio or video recordings, photos, and drawings. So this is one where it is a little bit broader, and that pertains to anything that's in the possession of the county is a public record and is typically subject to disclosure. That means that if it's kept on county servers, if it's a county email, if it's sent to the county, we're going to keep it. We have a retention schedule and we will treat it as a public record unless it's subject to any number of limitations on it. Those are long and exhaustive, and that makes up a chunk of my practice. But those exceptions are not something you probably need to worry about in the course of your business as a GRAC member. However, oh yes, Brian.
Okay. I just want to make sure I'm understanding this.
Mm-hmm.
If you go back to the private slide, you're saying that if I Google some stuff because I'm thinking about the upcoming agenda meeting, that could be a public record.
Again, it's something that I would encourage you to reach out to OGEC to.
Okay.
Yeah. And I'm sorry,
I get it, man. I get it.
Everyone hates when lawyers have to say that, but it's something we have to say. But I think in that situation, again, we're looking at something that's in the possession of the county. The county is not in possession of your computer when you're doing Google searches.
Right, but you say anything produced by, and I'm an official.
Produced by the official that's in the county records, and it's the sort of thing where that is broad. So sometimes, and I don't know, Kathy, if as part of this, they're provided with county emails for the purpose of GRAC. If they are, then the contents of that email will potentially be it. If you're sending emails to other GRAC members, then and I have heard of arguments where courts will try to get emails of committee members, even if those emails are not county emails. And that is something where it's a question of an individual operating in their official capacity. And that's something that is a little bit beyond kind of the scope of this question. And frankly, the advice that I can give, because I am counsel to the county, and when you're talking about something that was sent from a private email pertaining to GRAC business, that's something that's sort of sent in your individual capacity as a representative, but not sort of under the umbrella of someone represented by the county. So I know that's frustrating, and I know that
Oh,
that's.
but let me give you a use case, right?
Sure.
And I apologize. I'm really interested in this. So say 6 months from now, we, talk about, to my question earlier, the upstream stuff, how producers are making stuff. And we find out there's this big petition going on that's going to go to Washington, and we decide a way to put our name on it. The big company that's making XYZ is not happy, and they're going to start suing everybody who signed the petition. Now that falls right under you, Amon, right? Because you're like, hey, this is the advisory committee from Washington County. I'm thinking about stuff like that. Is that fair to think about? Because they may want to say, well, what computer did you use, Brian, to Google this information that you used in this committee meeting? That kind of thing, right? I'm
Yeah.
not being paranoid, right?
No,
I mean,
no, you're not at all. And again,
Okay.
the laws are broad, and they're
Yeah.
and that's not paranoid. That's the kind of thing that we have to do as lawyers. We're paid to be professionally paranoid. And the answer to that is, again, like I said earlier, it's the lawyer's favorite answer. It depends. And that's the sort of thing where I will tell you my practice, because before I worked at this job, I worked as a deputy district attorney over in Multnomah County. And I had, a personal cell phone, and then I potentially had a work cell phone. And in my job now, I have my personal cell phone and I have a work cell phone. I always do my business on my work cell phone. I don't provide my personal cell phone number. I don't give out that information, and I don't do it because if there's a text that's sent to that phone, then potentially it is available as part of a public record. And again, this is sort of my overarching thing, is just always assume that something's a public record. When in doubt, assume it's a public record. And so it's the sort of thing where theoretically, if you wanted to, and it just depends, and you can talk to OGEC and get some advice as to how you could do it. They might tell you something like, maybe you want to create Brian St. John Grack at gmail.com so that you know that you're doing that. I'm not sure that's something that's a little bit beyond the ambit of my practice, and I would encourage you to reach out to OGEC if you have questions about that.
Yep, no, it totally makes sense. No, I appreciate it. Yep.
Yeah. Okay. Are we okay to move on to the next chunk, which is about ethics? Okay, seeing some head nods. Great. Okay, so this is the last section. So we're getting down to the end of it. So you are now a public official. By serving on the GRAC, that places you in the very broad category of being a public official. Just like I am a public official, just like Kathy is a public official. And that means that you're one of an elected official, an appointed official, an employee, or an agent, whether or not you receive compensation for the services. I get paid to be here. You unfortunately do not get paid to be here tonight. But we both sort of fall under the same bucket of being a public official. And that means that you are subject to the Oregon ethics law. And again, this is another great resource where I'm going to point you that OGEC puts together an ethics guide for public official that will answer much more specific questions than I will go in here today. This should be a clickable link within this presentation that you can look at, and I'm going to send out the links to OGEC here at the end of my presentation. So what does that mean? Nope. If I can find the right arrow button. There we go. So as a public official, you cannot use your official position to benefit yourself, a relative, a household member, or a business with which you are associated. Relatives include a long list of folks. I've included that here. That's, spouse, children, children of the spouse, siblings, siblings of the spouse, spouse of the siblings, spouse of the siblings of the spouse, parents, parents of the spouse, and person for whom the public official has a legal support obligation, or a person for whom receives or provides benefits to the public official. So it's a pretty broad category. It's not your second cousin twice removed, or your uncle or something like that, but it is a pretty broad category. This again is a business. That's a self-employed individual in any legal entity that has been formed for the purpose of producing economic gain. It does not constitute a nonprofit if the public official is only a member of the board of directors, or is in another unpaid position. This describes if you are associated with a business. That means if you're a director, an officer, an owner, an employee, or an agent of a private business or a closely held corporation. If you hold stock or stock options or an equity interest or a debt instrument, worth $1,000 or more in any private business or closely held corporation. The person you own or has owned during the preceding year, stock or stock options, an equity interest or debt instruments of anything in a publicly held corporation, that is things that are traded on like the NASDAQ, NYSE, those sorts of organizations, or you are an officer or a director of a publicly held corporation. So what does that mean? Well, when we're talking about a conflict of interest, you have a conflict of interest if you are participating in an official action which would or could result in a financial benefit or a detriment. So either you make money or you lose money for the public official, a relative, so anyone on that sheet listed, or a business with which that official is associated. If it will, if you know, it's if you're awarding a contract to your wife's company, that is an actual conflict of interest and you must not participate. If it could be, if you are creating a bid and there's something where there are 3 companies, including one which might be your wife's company, then that's a potential conflict of interest. You may participate after disclosure. You have to announce the nature of the conflict at a public meeting. This kind of gets back to the first step of the argument, but again, this is why we're talking about open and transparent government operations. So you announce it, and then you proceed with the hearing. Now, an important thing to note is that for many of these things, when we're talking about public meetings and ethics, if the rules aren't followed, then potentially the decision that was made or reached can be unwound, which creates a headache for everyone. If you vote to award a contract or start something and it turns out that the public meetings laws weren't followed, it can be unwound for failure to follow it. If there's a conflict of interest, they can be sued. That can be unwound as well. So there are consequences here beyond just, you know, it looks bad or it's something that, you know, we're not supposed to do it, but there can be legal consequences for those actions. There are things that are not prohibited. Official compensation, that's if you're paid, reimbursement of expenses, if you have to travel for a meeting or something like that, we decide to host a meeting in Brookings, and everyone's got to drive down, then potentially that could be reimbursed. Honoraria, that is, you know, if you're going to go speak or give a talk at a conference or a school or a company, as long as you're being paid less than $50 and it's performed in relation to the private profession, avocation, or expertise. Awards for professional achievement, those are like Oregon Teacher of the Year. Those are things that are allowed. Now we talk about gifts. So if the source of a gift to a public official has a legislative or administrative interest in the decisions of the votes of the official, you can only accept gifts totaling up to $50 in a calendar year. And that means something of economic value. That could be a gift card. That could be, you know, a bottle of wine. It could be cash. It could be it's really anything that has any economic value. And a legislative or an economic interest is an economic interest distinct from that of the general public. So when we're talking about the general public, that means, well, as a taxpayer, I don't want my money spent frivolously. That's sort of the general public interest. If I'm a business owner and if I say own a construction company and I give a gift to a government official for whom I am lobbying or for whom I am applying to build a building for $1 million in that official's jurisdiction, then that means that there's probably a legislative or economic interest. Or if you're a member of a lobbying group or something like that, like if you have a legislative or economic interest, you can't give gifts or you can't receive gifts over $50. And those prohibitions apply to staff as well. And again, outside employment is allowed. Otherwise, we wouldn't have folks like you coming and doing the good work of being an advisory council. But you can't use your public position to create the opportunity for additional personal income. You may not use a government agency's supplies, facilities, equipment, employees, records, or any other public resources to engage in their private employment or business interests. If you're like, you know, I gotta go run some errands, I'm just gonna borrow a county car so I can go run and visit my clients because my car's in the shop. You can't do that. And officials are not to engage in private business interests or other employment activities on their government agency's time. That applies less here because we're just meeting here today. It's not, you're not like if I were to go out and start driving Uber during the day when I'm being paid by Washington County for my job as an attorney, that would not be permitted. And then confidential information gained as official is not to be used to obtain a financial benefit for the public official, a relative, a member of the household, or a business with which they're associated. A great example of this is someone who's involved in the planning of where a new road's going to go. If you know that a new road is going to be built near some properties, and those properties are going to have to be acquired in eminent domain, which means that they're going to suddenly become quite valuable, and you tip off a friend or something like that, or not a friend, but a relative that, hey, you should probably buy, you should buy this property because it's going to, the government's going to have to pay you some money for it. That's the sort of thing that's confidential information, assuming that information has been kept and isn't available to the public. And you would potentially gain a financial benefit because you would be in a better position to know which properties to purchase. So those are just a couple of the exceptions. And then there are relations on subsequent employment, which again is an official cannot use the official's position to create a new employment opportunity. You cannot use confidential information for personal financial gain, just sort of like we talked about with the condemnation case. And after you are done serving in the public body, you may not have a direct beneficial financial interest in a public contract for 2 years after the date the contract was authorized by the person acting in their capacity as a public official. So let's say you authorize a contract for construction for Jim Bob's Builders, and then you quit and go to work for Jim Bob's Builders 2 years, like within 6 months. You can't do that. If you wait 2 years and Jim Bob still wants to hire you after 2 years, then you can go ahead and work for them. But again, that's the date of the contract was authorized. So if you authorize the contract on the last date of employment, you can't work for them for 2 years. So again, I know I ran through a whole bunch of material on that sort of stuff. Again, like I said, I'm going to provide a link to the OGEC site. That is something where, again, this one is a much higher level overview. If there are any things you have any questions about, especially with respect to ethics, I strongly recommend contacting OGEC. They are a great resource. They have lots of FAQs. They have contact information. They can be a great resource for you if you ever are in a question in an area where you think you might have an ethics question or an ethics concern. I would certainly recommend contacting them. And again, sort of getting back to that grand overarching theme, if you have any questions about it, err on the side of asking or on the side of being too ethical. And that's the sort of thing where that's how I conduct myself, is that if there's any question, I ask. And you always want to err on the side of treating something as a public meeting, treating something as a potential ethics issue, treating something as a potential public record. I think if you do that, and if you use the resources such as OGEC, that can be a recipe for success in the realm of your new role, or not new, but the realm of your role as a public official. So that kind of brings me to the end of my presentation. Do you have any sort of general questions, knowing full well that I might give you another "it depends," or let me point you to someone else? I'm happy to chat. Yeah, Kathy.
So I'm just considering my role as the staff liaison for this committee, and just to make sure that from the committee member standpoint, how they interact with me in that role. Like when I think about it, I generally, like I said, I send out heads up. I give some general information about meetings, topics that are going to be on the meetings. But what happens if a GRAC member emails me with a question about something that may or may not even be on the agenda, but it could be on a future agenda, that kind of thing? Like, am I still a resource, or should we, generally speaking, knowing that you can't be totally, our attorney?
Yeah.
Where do we draw that line, I guess?
It depends, but I think that the thing to remember on that is that anything that they send to you is going to be a public record.
Okay.
Because they're going to be sending it to your county email, which means that it's a public record. So that means that that's the sort of thing where if they have a question about an agenda item, and let's say that agenda item ends up being the subject of litigation, and we get a lawsuit and they send a discovery request and they say, we want all communications from the county with the county regarding agenda item A, that email is going to pop up. So again, remember, and and this is something I got told when I started out my career as a baby public servant. Just assume every email you send to or through a county email is going to be printed on the front page of the Oregonian. And if there's anything in that email that you aren't completely cool with seeing printed on the front page of the Oregonian, don't include it. And sort of assume that everything you say and do is potentially going to be found and published. I have seen in at least one case an instance of a local paper finding text messages that say, boy, I hope these text messages don't show up on OregonLive.com. And you know what? They didn't show up on OregonLive.com. They showed up on OPB.com. So it's the sort of thing where just sort of assume that if you're communicating with county officials and on county business, it's potentially going to be discovered. Yeah, Ashvin.
Yeah, this might be a go look at OGAC website question, but there was a mention of like stock, possessing stock of where decisions are being made. And, since some of the haulers are like publicly traded companies, is that does that mean us having stock in a publicly traded company that is potentially affected by a decision, even if it's say not a contract specific decision like rates, that would be a conflict of interest?
Talk to OGAC. I think that's the sort of thing in here. I'm trying to find the chat icon that I can drop this in. But it's the sort of thing where that is something where if you have a concern about that, if you're holding stock, if it's a privately held or a publicly held company, I would contact OGAC and talk to them about it, because again, I can't offer you advice specifically.
Mhm.
I just know that if there's stock and if you've got a question about it, it's always a good idea to err on the side of checking.
Yep. Makes sense.
Yeah. Here, let me see. No, I am trying to find a link to, I don't see it anywhere, but okay, what I might do is I might just send those links to Kathy and have her distribute them to you so that you can contact this. Again, this slideshow is available. Does anyone else have any questions before I let you go? I'm not sure how long I was scheduled to talk. I think I went way over.
I just want to say thank you, Aman. I know I've asked a bunch of questions. Good stuff. I've dealt with lawyers in my current job, so I understand 100% where you're coming from. Appreciate you sharing.
Absolutely, happy to help out.
Yeah, thank you. I think it clears up a lot of stuff that we've been considering, so very helpful. Food for thought.
Okay, great. All right, well, I'll send Kathy those links, and I hope you have a good rest of your evening. So it was nice meeting you all.
Thank you.
Yeah.
Bye-bye.
Alrighty, we can go to the last item, which is oral communication again. Give opportunity for public attendees to raise their hand for public comments or questions. If not, any final thoughts from anybody? Otherwise, we can say good evening and thank you all for attending. All right, bye everybody.
Thanks,
Bye.
everyone.
This concludes our meeting. I'm stopping the recording.